afternoon. You can be seated. The matter before the court is State of Maine versus Jeffrey Witham, and this is Hancock 23-421. We are being streamed live on the web, both by audio and visual. And if counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Rory McNamara for the appellant, Jeffrey Witham.
Tough on State of Maine.
And counsel, if you're ready to proceed, Mr. McNamara, we're happy to hear your argument.
Thank you, Your Honor. May it please the court, counselor. The state's singular argument seems to be that defendant was not entitled to a pretrial hearing. Yet the U.S. Constitution and Maine statute both independently require such a hearing. The error is as plain as errors come. Respectfully, it was equally plain nearly 2 years ago when defendant demanded a hearing. To now give any remedy short of a new trial and the return of money would be to encourage sandbagging. A defendant's chances of prevailing are hurt by delay of this kind, and this court should not incentivize the state arguing against hearings that obviously must occur. Memories fade, pay stubs and receipts disappear, particularly when you're incarcerated. The state has not once asked for a hearing required by law. It's simply too late to do so now. I'll add that the principle of party presentation probably precludes it as well. If there's any time remaining, I'd cede it back to the court. Welcome questions.
So doesn't the request for a hearing, however, belong in the case in which the money was seized?
So it was made in that case.
And
in
it could be
case.
Reviewed in that case.
Well, it was
at some point
made in several cases. So made in that case and in these two docket cases. Yeah. So if Your Honor were to look at page, I believe it's 112.
Well, I understand it was docketed that it was made in more than one case, but doesn't it belong solely in the case in which the money was seized?
No, it doesn't. It also belongs in a case in which it's necessary to hire counsel, which is this case right here. In this case, the defendant claimed that I need that money in order to pay for counsel of my choice.
What if it had been seized in a case from another state or by the federal government?
Well, I think that muddies the waters a little bit as to the logistics of how it ought to happen.
Would you still be entitled to a hearing in this case?
Absolutely.
Could a judge order that money returned?
Could a judge in another jurisdiction?
Assume it was taken, like I say, whether in another state, by the federal government, whatever.
I think, yes, absolutely, could issue an order that says, look, this money is necessary in this state, in this jurisdiction, or the federal government, to pay for counsel. It needs to be returned. And then the receiving state, if you will, receiving jurisdiction, it's up to them to decide whether or not they want to honor that, if they want to have strong, fundamentally sound convictions or not. And certainly the conviction in this case has been obtained without the necessary hearing that's both required by statute and by the Constitution, and quite clearly at that. And I think now, 2 years on, I think it's going to be to my client's disadvantage to go back after being incarcerated that whole time, to go ahead and position everything as if nothing has happened.
Was there a hearing of any kind, whether evidentiary or not? Was there a hearing of any kind held in the drug case?
No, to my understanding, there has not been, and certainly now, this is a difficult question, another one to answer about jurisdiction, whether or not, given this appeal here, there is jurisdiction to decide, now that this appeal is pending here on the remaining drug case, whether anything there could be decided regarding this issue while this appeal still pens in the trial court.
So how can we make a decision in this case with respect to the money in the drug case that was allegedly subject to forfeiture, to the extent that matter is not currently before us?
Well, Your Honor, that matter is not the only docket number that has been docketed under the motions for the hearing. The request for the hearing on page A12 of the appendix was under those, I believe it's 3 separate, 2 in this case, docket numbers, and the docket numbers in the drugs case. So what needs to happen is a hearing consolidated to all three of those matters, which could happen on remand. It is defendant's argument today that a hearing such as that is something the state has not asked for at any point. And party presentation would certainly dock a defendant or his counsel for not asking for that. And at this point, the state hasn't asked for that hearing. It's time to return the money. The statute requires a prompt post-seizure hearing. That certainly has not happened.
Did he request the consolidation below?
He, in so much as he put three docket
The docket numbers on the motion.
on the motion, yes. So I think that that's certainly for a pro se defendant, that's a pretty savvy thing to do.
Well, the
if you
court
want
also
cases to-
recited all four dockets and held the hearing that seemed to relate to all those
Right.
dockets.
And two of the attorneys for the state, both in the drugs case, and it wasn't Attorney Toffelon, it was his predecessor on this underlying case, underlying two cases, was there as well. Yeah, so there was a hearing. It was not an evidentiary hearing. At that hearing, appointed counsel asked for the opportunity to present witnesses and evidence on this issue. So I do think it was adequately preserved.
Well, he
in
asked
that
for a
regard.
continuance. He didn't, to present witnesses at a later time,
I
right?
think it was unclear whether, certainly at that point when you're there, ready for a hearing, when there's been no discussion about whether or not witnesses could have come forward at that date, I think he was saying we need a continuance in order for me to present those witnesses, but yes, we would like to present them. It was almost like a pre-hearing, if you will, to decide whether or not the defendant was entitled to an evidentiary hearing.
Well,
the
and it
defendant
wasn't denied on the basis of, no, you don't deserve a continuance. It was basically, I'm not going to give you an evidentiary hearing.
I think that's fair to say. Certainly, I don't think he was going to give a continuance based on his reasoning either, the judge, that is.
Under Section 5826, the trial against the property says may be by jury and must be held in a single proceeding together with the trial of the related criminal violation. Before having a hearing then to return the property, does the defendant have to execute a waiver of the right to jury on it?
No, because I think the trial will naturally come later. You won't have an entry of a forfeiture. You won't have a criminal conviction, if
Well,
you
is it
will, for the forfeiture.
returning the property essentially denying the forfeiture?
Returning the property to the defendant, certainly, but that is not a right. I think that if you have exercised your right to a hearing, you've demanded your right to a hearing, you're probably going through the steps of waiving any, it's not even a negative result that would accrue to you if you were to win that hearing. I think you naturally want that money back there, and that's what you're signaling when you are saying, I want this hearing now. Now, I understand it does get a little bit more muddy were you to lose, were the defendant to lose that hearing, but I think still thereafter there's the opportunity to prevail in front of the jury.
Well, the statute
that.
sets forth a two-step process for seized property, the initial restraint and then the forfeiture. And the initial restraint is based on probable cause. So what was he requesting the court to hold a trial on the forfeiture, or was he simply asking for reconsideration of the order seizing the funds?
On the forfeiture, he was offering evidence that would have shown that this is money. I don't have the motion in front of me, but there's language in there, if I recall correctly, that says something along the lines of, I was saving up this money, I was earning this money to pay for counsel. This was right to the question of forfeiture, not to the question of probable cause writ large that the court
So
said
it was
in-
not a collateral attack on the grand jury indictment, in other words, you're saying?
Correct. And the Supreme Court in Cayley made the distinction quite clearly between the two types of hearings, and the former, the one that just attacks probable cause as a collateral attack, you might say, is not required under the Constitution. We're not arguing for that today. We're not asking for that. We're simply arguing for the opportunity to put forward evidence as to traceability, as to the forfeiture, as to whether or not those assets are something that are properly before the court to be seized.
What you want is for the state to try their case.
Well, no, that's the distinction, and the court made that in Cayley. If you're asking only for the former, for what Cayley said you don't get to attack probable cause as to the indictment itself. That would be previewing the case in a way that might be unfair to the government, at least in the constitutional analysis.
Oh, no, essentially you're
occurred.
conceding probable cause is what I understand, but you still, the government, in order for the defendant to, wants an opportunity to prove that the proceeds are really fairly gotten, the state also will have the opportunity to prove that they were in fact ill-gotten, which
Right.
means the state has to try their case. And again, I'm struggling with the right of a jury in that.
Well, I also am concerned about the interest of a defendant in saving until trial his discovery and his strategy.
So wasn't the proper procedure in this circumstance then, after the proceeding on, I think it was January 18th of 2023, you get the decision from the court saying, well, there was a determination made in the underlying drug case, and to the extent that the money was taken, everything seems to be appropriate there. Wouldn't the appropriate step based on that determination would have been to make an interlocutory appeal?
No, I don't think so, because the issue was still, we wouldn't be here if my client was acquitted at trial, or if my client had prevailed at trial or on a different motion. We wouldn't be here. So the whole point of an interlocutory appeal, I think, in those circumstances is, well, defeated.
Well, except your point was, by not having the money in the first place,
Right.
it's not valid.
But
So-
that's the fire that the state plays with when it's both required by statute and the Constitution. You have a constitutional right, and all along, including in the red brief, they have denied the right to a hearing. So I struggle to see how it suddenly
Isn't that
became-
all the more reason to file the interlocutory appeal to get it before this court, to the extent that your client's being deprived, he says, of the opportunity to hire the counsel of his choice by virtue of this determination that's been made with respect to the forfeiture or the restraint of the proceeds?
I'm aware of no precedent that says it's appropriate in these circumstances to file an interlocutory appeal. And in fact, the
Mr.
request...
McNamara, I've never known you to be hesitant to break new ground.
I was not handling the case at the time, of course, but also defendant had to perfect his request for a new trial, and he did that after trial. He couldn't have done that before trial.
Can I ask you a question that's really kind of off the mark, but I'll ask it anyway? I take it the drug case has not gone to a verdict.
That's correct, yes.
So let's say it did, after the fact, he was found guilty of that, and it was found that, yes, these proceeds are subject to forfeiture because they were part and parcel of that. Is it possible that that result could retroactively moot what happened down below?
Not in this case.
Because?
Because 2 years have passed. And 2 years is an awful long time for a man incarcerated to be able to go back and place into context where that money came from exactly. And that's where we're dealing with such significant harm. Thank you.
Thank you. Counsel?
The state contends that 1526-4 is dispositive of this issue. It says, trial against property charged by indictment, that is the drug money, maybe by jury, but must be held in a single proceeding together with the trial of the related criminal violation. There's no opportunity to give the money back before he has his trial in the drug case. I'd like to use the rest of my uninterrupted time to address a few things that Brother McNamara raised in his reply brief, and the first touches on the identification of multiple defense attorneys in refutation of the state's argument that Mr. Fenstermaker, the preferred attorney, could not be utilized. I respectfully remind the court that no other attorney, potential defense attorney, was identified, and the state asserts that the defendant would have to show some actual prejudice in any regard. Now, he didn't apply to MCLIS or the court to change his attorney to another court-appointed attorney. He didn't indicate that his trial attorney was incompetent. He hasn't filed a PCR. So does the defendant have some burden to show actual prejudice from the court's refusal to give him a hearing on the release of his funds so that he can hire a lawyer? And I do want to comment on Brother McNamara's reply brief analysis of the mental exam requirement. Again, how does he show prejudice? He denied the court's inquiry about whether he wanted to have a mental exam before the trial. He presumably had the defects that he complains of now in his brief before his trial, and so he can show no prejudice. Further, he could have petitioned MCLIS for funds to hire a private forensic examiner had he been aggrieved by Justice Larson's decision to deny the request.
I see that the green light is on. Can I go to one of the issues that we didn't talk about with Mr. McNamara, but with regard to the sentencing and the use of a failure to accept responsibility as an aggravating factor versus the use of an acceptance of responsibility as a mitigating factor? Is it time to have a bright line saying a failure to accept responsibility can never be an aggravating factor? In other words, we're really setting up a dichotomy where it's either a mitigating or an aggravating, but that's a false dichotomy, isn't it?
That's a policy decision that doesn't apply retrospectively to Witham, Judge. Also, I'd say that
what does apply is we've said you cannot punish somebody for exercising the right to have a trial.
And
by failing to accept responsibility, isn't the judge, I mean, I've read it and I've read it, and the judge really pretty much seems to be saying, you had a right to have a trial, but when you had a trial and you were found not to be credible and found guilty, that's not an acceptance and that's an aggravating factor. How is that different from punishing somebody for exercising the right to have a trial?
you already decided that in Grindle, didn't you?
Well, I don't know that we have, and we've been wrestling with it. It keeps coming up. We are wrestling with it.
And I respect your decision to change the course of future proceedings, but Grindle is the law now. Grindle applied at the time that Witham was sentenced.
But we have never said that it's okay to punish somebody for exercising the right to have a trial, to simply say that by having a trial and having been convicted, that is enough to say that that's an aggravating factor for a failure to accept responsibility. We've never said that.'t
language was pretty clear, Judge, and I would respectfully ask you, as you've said, you've read and reread it, A88 sets forth clearly Justice Larson's comments. If you extract what the reply brief quoted, you've got a problem, perhaps. But if you read all of A88 and you see Justice Larson's...
Have it open.
Yep. So...
So he did here exercise his right to allocution, but he said something sort of went sideways. I apologize. I apologize that I went to trial here because those guys made me go to trial because they didn't make an agreement that I accepted. Does that overlap into that failure to take responsibility, that sort of blaming other people for the fact that a trial had to be held?
Well, now he blames the state because it's not part of the record, so I'm hesitant to bring it forth, but a plea agreement on much more favorable terms that he ended up with was extended and rejected by Mr. Witham. So instead of focusing on the matter at hand, that is discussing with the sentencing court the ramifications of the trial outcome and his reaction to it, he veered off and said, in essence, man, I wish I'd accepted that plea bargain.
But what I'm asking you is, if he didn't make an allocution, we wouldn't be talking about this here today. But the court seemed to really key in on the fact that he apologized for something that you did, which is not to come to an agreement, putting the blame there as opposed to taking any responsibility for anything else. Did that factor into the judge's? Well, the judges cited it specifically in pronouncing sentence.
And that's appropriate. If you're
well, an allocution is a partial waiver of their right not to testify. So if they allocute, then why can't the judge say, I've listened and I'm not hearing any remorse in what you're saying. You have a right not to say anything, but here you're saying things and not hearing remorse.
And as Justice Glassman pointed out, Justice Connors, that's perfectly appropriate for the sentencing judge to consider.
But let me get back to the first issue, the funds, because I want to understand what your position is. So there's a motion in all the dockets that says, I want to have these funds back so I can hire the counsel of my choice. And there's a non-evidentiary hearing in which the lawyer cites the statute and also cites the Constitution and says, I want a hearing, evidentiary, that will show that these funds were not related. And the result of that is he doesn't get an evidentiary hearing. So you're saying that's okay because?
Of 1526.
Because the statute requires you to do what?
The statute requires the court to hold a hearing on the issue of forfeiture must occur at the time of the trial on the
So you're
merits of the
saying
charge.
he doesn't have a constitutional right to an evidentiary hearing on this before the trial? That's your position?
I'm saying the court needs to give weight to 1526 unless you want to tell us it's unconstitutional.
Well, we have a statute, but we have a constitution. And the Constitution trumps statutes. So are you saying there is no, and he cited the Constitution. So are you saying there is no constitutional right greater than what's provided in the statute, and you're reading the statute as not requiring an evidentiary hearing?
I'm no constitutional scholar, but my direct response to your question is, if that were the case, Judge, how would MCLIS even function? You're not guaranteed the lawyer of your choice when you have a court-appointed lawyer. You're guaranteed a competent lawyer. So the trial courts would routinely be confronted with a request that I want Walt McKee to try my case on an appointed basis because I've got a constitutional right to have the lawyer of my choice.
No, that's not the argument. The argument is not that you get the lawyer of your choice on an appointed basis. The argument is I have the right to hire an attorney of my choice if I have the funds to do so, and he's claiming he did have the funds to do so, and the state was wrongfully withholding those funds. Those are different arguments.
Well, again, I can't claim to be a constitutional scholar. All I can say is the state and the courts below you operated according to the statute and did justice according to what the law was at the time. And if you prospectively change it, you change it.
He would have had a hearing at the unified hearing, right? The motion he's pursuing would have occurred. He wasn't denied the right to have a hearing. He just had to be unified with the other matters.
Well, what other matters are you referring to, Justice Meade? The other matter that I'm referring to is the trial on the merits of the drug case.
That's what I'm saying.
Oh, okay.
He would have that right down the road. So if there's a constitutional issue raised here, it's whether he had some constitutional right to have an independent hearing in contravention of statute before he would have had his hearing at the trial.
Correct.
And isn't there some federal law that says he is entitled to that?
I don't know.
I asked Mr. McNamara that if this trial, the drug trial takes place and the forfeiture takes place and he's found guilty and the forfeiture is ordered because it's connected up with a drug offense, I said, would that retroactively moot what happened down there? And he said 2 years is too long. Did you have a position on that?
I think that's a horror show that we'll try to reserve for another appeal, perhaps. But my attitude is 2 years isn't too long. If he filed the motion, he had the requisite pay stubs and other things that Brother McNamara referred to on hand, presumably. He wanted to present witnesses and he wanted to present this paperwork, apparently. There's no evidence that those items still don't exist.
But he wouldn't have gotten a hearing under your analysis because it had to wait until the trial for that unified hearing.
Correct, and I'm saying the passage of time, which was what I thought you asked me a question or two ago, isn't material. Because he still has the resources for the hearing. But I can't see how the state can be deprived of saying, we can prove that $27,000 was the fruit of drug trafficking. We've got to do it at a trial. We don't want to have a trial within a trial, which the last set of attorneys who appeared before you discussed. We don't want to have a trial in front of in a trial here. We want to have one unified trial. That's why we have 1526.
Well, you don't want to do a dress rehearsal of the evidence of your case in one proceeding and then go into the same evidence at the actual trial for the drug offense.
Why not just have a trial? Why not just when he makes the request to have it returned, and if there's a right to have a trial, it's like, fine, that triggers, you're on the next docket call for this drug case.
And I think that's wonderful, and I'll use 10 seconds of time, if you'll allow me, to compliment the court on finally assigning a full-time local judge to Hancock County so that we now have 9 months of trial time. But this all didn't occur during COVID, and then we didn't have a local judge.
But isn't the problem here that Cayley, the government even conceded that you get an evidentiary hearing pre-trial. And then the lower courts of appeal have said, yes, you do. And don't we need to confront that when we're making this decision on appeal now? And how can they show prejudice in something, isn't this a structural problem because you can never show how you'd be prejudiced or not prejudiced by not getting your right to a counsel of choice?
Well, I don't know that having the right to your counsel of choice is a right guaranteed by the Constitution. You're guaranteed competent representation, free if you can't afford it. And again, I get back to the issue of he needs to show some prejudice. He can't.
It's in our Constitution. The Maine Constitution says you get a counsel of your choice.
If the counsel of your choice will agree to represent you.
You can afford it. You have to be able to pay for it, and then there are some limits, but there is a constitutional right to your counsel of choice, isn't there?
Well, if there's a constitutional right, and I know what your response will be, he didn't get his hearing so he couldn't show it, but wouldn't he be appended to his motion a letter of engagement from the lawyer saying, if you get your 27 grand back, I'll represent you? But what he really wanted was Mr. Fenstermaker. Please remember, he identified no other lawyer. That was just a throwaway line. He wanted Mr. Fenstermaker. Mr. Fenstermaker was not available.
It seems to me we should be, and I think the appellant is asking us to view his motion to the court, which was made in multiple docket numbers, as in effect a motion for speedy trial on the drug charges, and in effect, or a motion to sever the forfeiture counts from the other charges in that case and have a trial, speedy trial on the forfeiture charges. Because you're right that the state can't be deprived of its right to prove, if it can, that the funds being held were associated with an illegal drug transaction. So could the court in this case have continued the case that's on appeal and scheduled a trial on the forfeiture charges, or perhaps all of the charges in the other case?
Justice Horton, I think that's a great idea. As I just said, we have Justice Stewart up there. He's hammering out trials right and left. Issue an order that says this case has got to have priority. We'll let Brother Horn try it, and if he wins, we're going to keep the money, and this will be moot.
Did the court abuse its discretion by declining to do that?
No, but even if it did, you've hit upon a perfect remedy.
Thank you,
But
counsel.
sorry, is opposing counsel correct, though, that that's a structural error?
I'm sorry,
Is opposing
Judge.
counsel correct that the failure to hold that evidentiary hearing is a structural error?
I don't know.
Thank you. 548 U.S. 140, Gonzalez-Lopez says it is structural error. It's structural error to deny the opportunity to hire counsel of one's choice. So that's not a point that's open for debate here. I also want to push back on the notion that somehow a hearing is the same thing as a trial. Hearings happen all the time. Pre-trial hearings happen all the time. And that's what we were talking about here. And that is what is required by the statute, in addition to the Constitution, under 5828(1)(a). I'll read it. Following the seizure of property, a defendant or any person with an interest in the property has a right to a prompt post-seizure hearing. Very plain language. Of course, any interest in property implies, quite plainly, that there's an opportunity to litigate what interest in that property you have. And the Supreme Court's case law, certainly the Cayley decision, the Luis decision, made it very clear that there is no...
Well, the problem is that that statute says you have a right, and the Supreme Court, you have a right to a hearing, but then whatever it is, 5826 says...
Trial.
Trial. But as I proposed, then it could be...
Right.
Parties could waive the right, I think, to have it done in one trial, but...
As in the context of a suppression hearing before trial, when you go through and you litigate what was the seizure of property perhaps attended to a probable cause or a search warrant, was that legal? Was that lawful? That property would be returned at that time. And this is very similar to what we're asking for in this context, which is a pre-trial hearing at which you get your money back if you can prove what needs to be proved according to the statute.
What about the impossible, in effect, the state is presenting an impossibility defense based upon the suspended status of the attorney that Mr. Witham indicated he wanted to hire.
Thank you. I appreciate that question. I will go outside the record because counsel went outside the record. I have seen from another lawyer the certificate that says, I'd like to be, pay me $25,000 and I'll be your lawyer. So that was there, and that was represented on the record that there are other lawyers to be had here. So that's not something. Also, I push back against the notion that the state is due the opportunity to defend against the possibility that this money is not traceable here. The state has agency through its attorneys, and those attorneys have not argued until the very last second of oral argument that there should be any opportunity to do so. All the time in criminal cases, we see defense attorneys waiving, abandoning, forfeiting proper standards of review, arguments, entire remedies, losing trials, and those consequences have effect on defendants. And I think it's important that those arguments that are made by counsel for the state have very similar effect here. In this case, that's what's due. Thank you.
Thank you. All right. Well, thank you, counsel, for this interesting argument. As is our usual practice, we will be taking the matter under advisement and issue a decision in due course. And with that, we'll be in recess on this matter.
All rise.
and you may be seated. My apologies for going as late as we are. The matter before the court now is Penobscot 23-461, State of Maine versus Angelina Quirion. And if counsel would identify themselves by saying their names for the record, together with the party represents, starting with the appellant.
Thank you. Good afternoon. Rory McNamara for the appellant, Angelina Quirion.
Good afternoon. Jason Horn on behalf of the state of Maine.
Thank you. And as is usual, we are being streamed live on the web, both by video and audio these days. If you are ready to proceed, Mr. McNamara, would be happy to hear your argument.
Thank you. May it please the court, counselor?
And I note that you decided to not protect any time
That's
here,
right.
so I'm going to take advantage of that.
Right.
Let's assume you're correct and that there is evidence to support the statement that was made by counsel in the closing about the possession of the Walmart bag. I think there is.
Yep.
Is that really to sustain an objection? How is that a comment on the evidence?
I'll give you two cases where this court has held it was a comment on the evidence to sustain an objection, to rule on an objection. The first one is State v. Linnell, which is 408 A2D 693. It's a 1979 case. There, the issue was whether or not the defendant could act in self-defense. The trial court sustained the prosecutor's objections, saying when the defendant was testifying, the defendant was asked something along the lines of, do you think you could have stopped him without using self-defense? And the trial judge, following the prosecutor, said, no, that's mere conjecture that you could do that ruling. Because, of course, it was evidence that was being offered by the defendant. So that's one example. A second example is State v. Varney, 641 A2D 185. There, the court overruled the state's objection to certain defense evidence. The judge said, oh, I'm going to admit it, but only for its marginal relevance. In that case, the law court didn't reverse, but it said that was an improper comment on the evidence. It didn't reverse only because it didn't deal with a controverted fact, so it didn't fall within the statute precisely. And it turned out, so harmless error applied, in other words, to that particular comment.
And that was going to be my next question.
Correct.
Is assume we say, well, that's sort of a comment on the evidence. Does the statute require us to vacate at this point without regard to any analysis as to harmless error, as to whether the later instruction with regard to who makes the decision as to whether it's up to the jury to decide what the evidence is and what the evidence means, any of those things that we would normally, an analysis we would normally engage in other
Normally consider,
circumstances.
correct. And I'll answer the question both ways. And I do think that structural error applies. I think that is the language of 1105. It is sufficient cause by itself for a new trial if either party aggrieved thereby interest desires it. So that's point number one. I think in the Kessler decision, that is kind of the inclination. It says as long as there is a comment on a controverted rather than an uncontroverted fact. So that's where it's almost like a quasi-baked-in harmlessness analysis. If you think everything about uncontroverted facts is going to be harmless, and then those things about controverted facts are not going to be harmless. They fall within that statute. The third point is the state hasn't disagreed. In its red brief, there was no argument that says this is not a structural error per 1105. So I think those are three reasons why harmlessness error doesn't apply in this case. But even if it does, I'm going to argue arguendo, just for the sake of it, that it's not going to be ever, well, I can't say ever, it's going to be very difficult to be harmless when a defense counsel is cut at the knees. His credibility is cut at the knees in the closing arguments by saying, no, that's not in evidence, when in fact it is. There are just too many constitutional rights at play, such as an impartial jury, such as having an effective closing argument, having your attorney making an effective closing argument to do that. It just also kind of flies in the face of how we think of jurors evaluating credibility. They're supposed to be the fact finders. They're supposed to be the ones doing that. It also makes
Does it need to be addressed to the trial court in the first instance? In other words, if you read the statute, it says the expression, assuming that was an expression of opinion, is sufficient cause for new trial if
Right.
either party aggrieved thereby and interested desires it.
Yeah, I agree that specifically, that point, 1105, wasn't pointed out by defense counsel. However, defense counsel certainly in the moment objected, said, no, that was in evidence.
Mm-hmm.
Then thereafter closing, got up and said, I'm asking for a mistrial. And one of the reasons I'm asking for a mistrial is because that was in evidence, and then was renewed, I think, one more time on top of that. I think that's adequate preservation, considering the standards we usually have, which is, are you bringing to the attention of the court what you are asking for? And certainly was asking for a new trial here. Back to my list of things, reasons why, even if harmlessness analysis does apply, why this is not a harmless error. I think there's another point. The state agreed that it needed to prove a continuing course or scheme of conduct in this case. And this one kind of falling right in the middle of those three events could be seen as hollowing out the proof of a continual scheme or course of conduct. So those are both primary arguments for why it's structural and why, even if it's not structural, why the error is harmless. I can transition next to the next argument. Next argument has to do with the fact that there are the court's very statement in Fagone, which is whether prosecutors' conduct, any conduct, or judges' conduct, any conduct, might have prevented a witness from fully testifying is grounds for reversal. And in Webb v. Texas, that was the similar standard, very capacious, any conduct that could have prevented a witness from fully testifying. I realize that as...
Strout testified.
Yes, both of them testified, correct? Well, no, I'm sorry. Ms. Strout testified.
Yes.
Thank you, I misheard you. Ms. Strout testified. Mr. Simons did not testify. The error as to him is unpreserved. There was no objection at the time. There's certainly a long colloquy on the record, including the prosecutor putting on the record how he, another prosecutor, and at least two law enforcement officers went out into the hallway and said, we're not calling you. We've listened to your phone calls in jail. The implication being that we think you're lying, and we're no longer calling you. In addition, I think there needs to be an inference drawn that all the
But isn't that,
information...
when you start talking about that, I mean, at the same time, doesn't the witness Simmons have the right to be told, ooh, by the way, you could have a problem if you testify in this case, particularly if you testify along certain lines. I mean, what the Supreme Court, what the case law is aimed at is undue, essentially, pressure.
Undue.
And on the record, we don't know what was actually communicated to Simmons, do we?
Well, we know that one representation about what the conversation was. At least two police officers.
But isn't that a problem if we don't know what was actually communicated to him?
Well, I think you can infer from that when you have at least two police officers.
He should have been claiming his Fifth Amendment right and not testifying.
Perhaps, but that is a warning that should come, I think, just from the judge and maybe your own attorney. In fact, one of the cases that's cited in the briefing is the Thomas case. And the Thomas case is a Federal Circuit Court of Appeals case. And I'm sorry, I don't remember which circuit court it was. But there, a judge had warned a witness, hey, maybe you need to go talk to a lawyer. Really, the way this ought to happen is you ought to be fully informed about the risks before you testify. The Circuit Court of Appeals said that's exactly what should happen. What happened next was gratuitous. It said, out in the hallway, taking a break, the potential witness could not find a lawyer and talk with a government agent, just one of them, not two of them, not three of them. And the agent said, yeah, you could be prosecuted for doing this. And the Circuit Court of Appeals said that's gratuitous. So I think following Webb and following Fagone closely, that's a very capacious standard, as I said. Any conduct that could drive someone off the stand. And that's what Thomas is applying there in this case. They're saying, well, it's gratuitous, it's extra, and it shouldn't happen. So I think it's very little that needs to happen from a judge, and certainly the defense counsel or the counsel for the witness can deliver that message.
Well, it's in my experience in the trial courts, it's fairly common in criminal cases for prosecutors and defense attorneys to advise the court that an unrepresented witness will be questioned on certain areas that may create some exposure, not involving the witness at this point. And what courts often do is arrange for an attorney to be available to counsel the witness on whether to invoke, and the court obviously wants to find out without the jury in the courtroom whether the witness is going to invoke their privilege.
I think that's best practice, and that is practice that happened here. It's what happened in addition to that. On the record, there were all kinds of representations about what will happen to Mrs. Strout and Mr. Simmons should they go ahead and testify. And then in addition to that, we have the meeting in the hallway between the prosecution and this witness without his attorney, which is problematic. I think.
Well, if the judge cannot find an attorney to represent the unrepresented witness with what the judge is told is potential exposure, is there anything wrong with the judge saying you have a right to avoid testifying in a way that might incriminate you, and you're going to be questioned, as I understand it, on the following areas, and you need to decide what you'd like to do?
Unless there's anything contextually odd about that, like that's the only witness, or it was said in a particularly slanted way, I don't think there's any problem with a judge saying something like that, a one-time deal. No, I don't think so.
Are you advocating for a rule of law that says if the state's attorney, the prosecutor, goes to the witness and said, you're going to be prosecuted because this is what we know about it, are you advocating for a rule of law that is never permissible?
Yeah, I think that needs to come through a witness's attorney if that happens. And I do think that that is, in fact, not a new point that I'm advocating. It's perhaps a clearer statement of the existing law. Right. I think the prosecutor has a very impactful position as the agent of the state and the chief law enforcement officer in that particular case. And that message is going to come across in a particularly dissuasive way, I think, when it comes from the prosecutor.
We're actually on red.
Oh, there's
Okay.
the red light.
Red light, thank you.
I can see the timer.
Oh, okay.
I was like, we've gone past
I thought you were talking to Joel.
I kind of was. It's because I had a question to ask, and I was like, oh, there's no time.
May it please the court, counsel. First, I'd like to draw the court's attention to the fact that more so than in most cases, there's a very wide gulf between the appellant's statement of facts and the appellee's statement of facts. And I would encourage the court to directly go back to those points in the transcript, because there is a strong disagreement about what exactly the record shows as to each of these arguments. As to the objection at closing, this is reviewed for an abuse of discretion. There was no evidence that Jalbert claimed ownership of the Walmart bags specifically. There was evidence that Jalbert claimed ownership of the bags underneath his seat, and there was a hearsay statement that came in as from the defendant that indicated he brought the Walmart bags to the vehicle. But to the best of the state's recollection, there is nothing in the record that shows that Jalbert claimed ownership of the Walmart bags. And procedurally, what happened was exactly the bare minimum that is required by the rules. Parties are required to state the grounds of their objection succinctly. That does not make it a speaking objection. It just makes it minimally sufficient under the rules. The objection was objection arguing facts, not in evidence. The ruling was simply sustained, move on. There was no further discussion by the court on the record before the jury of this objection. The state cannot conceive how ruling on an objection standing alone could constitute a ruling, a comment on the weight of the evidence. It beggars what the appellant is asking here. Is it to prevent the state from having the ability to object during closing argument? Is it asking the court to simply refrain from ruling on objections by the state during closing argument? The state's certainly familiar with what a speaking objection was, and that was not what happened here, nor was there any comment. The case that was compared to in the brief was Edwards, and this is completely distinguishable from that kind of fact pattern. In Edwards, the court gave tons of information, including a detailed outline and a chronology and hard copies thereof to a jury to use in deliberations. Here, the court properly instructed the jury that you're the ultimate finders of what the evidence and facts showed. As to the defendant being prevented from calling witnesses, that's simply not true. Neither argument is preserved either, not Simmons nor Strout. Both are reviewed for obvious error. Strout is not preserved just because defense complained that Strout's attorney was going to get to talk to Strout before he was. There was no objection made. There was no ruling sought. That does not preserve a claim.
If I heard Attorney McNamara correctly, I believe he would advocate for a bright line rule of law that says that prosecutors cannot accost defense witnesses and with the threat of prosecution. What, if anything, is wrong with the bright line rule that says that?
Well, first off, that's not what happened here.
I'm just getting theoretical here. Just hypothetically, if as a prosecutor, would you be amenable to a rule that says you can't go to their witnesses and threaten them with prosecution?
Theoretically, and that sounds reasonable. But again, that's arguing totally outside the record as to this case. The only thing the state would have done differently is perhaps physically drag Brother Toothaker into the hallway with us to be a party to the conversation as well. But the record is what it is. He was advised that both parties had listened to the phone communications and nobody was sponsoring him as a witness. The defense never attempted to call William Simmons as a witness during the trial. And in fact, the defense articulated lengthy reasons of valid trial strategy where it would not be in their best interest to attempt to call William Simmons as a witness at that point. Moving on to Sierra Strout. Again, her attorney was informed about a new pending investigation, of which the state knew limited information at that point. They were also informed that she was the girlfriend of the cooperator who already testified that he was selling drugs on behalf of the defendant, and that there was an outside possibility that she could inculpate herself in that offense. Her attorney spoke with her. Notwithstanding that, Ms. Strout testified anyway. And I feel like we would be having a different appeal on a different case had that not happened, because it would seem fundamentally unfair to allow Ms. Strout to take the stand and not advise her counsel of these potential areas of exposure for her before she chose to testify. There was nothing improper about those admonitions. There was nothing verbose or outside the realm of normalcy. The cases that the appellant cites as far as essentially tampering with a witness by over admonishing them. And Webb involved a lengthy and pointed admonishment with a direct threat from the judge to personally ensure that they got indicted and served years more in prison. In Fagone, there was detailed warning about specific crimes, penalties, and repeated that they could elect not to testify 3 different times from the court. In Morrison, there was an invalid subpoena issued to bring a witness to a prosecutor's office, not the court, so that that particular prosecutor could personally threaten them outside the presence of the court. In McCloskey, they told the witness attorney in advance that they'd be well advised to tell the client that they could be re-indicted if they testified. None of these are similar to what actually happened here. For starters, Simmons was never admonished by anybody in any way, shape, form, or fashion. His attorney was brought into the loop. His attorney indicated, as the record shows, that he was never able to even actually make contact with Mr. Simmons. And Mr. Simmons never came into the courtroom to ever get any kind of admonishment by the court because everybody decided they weren't calling him.
Is the tipping point on all of this in State versus Fagone? We said that advising a witness is perfectly okay, but drove the line to emphasize the point that if the statements are threatening or intimidating, that crosses the line into the prohibited conduct.
I think that's exactly what this is about. Fagone acknowledges expressly that there is a competing interest in advising people like Sierra Strout.
And your point here is that the record does not arise to that level of threatening or intimidating.
Yes, Your Honor.
Well, aside from threatening or intimidating, do we have to find or conclude that remarks by either the state or by the judge effectively or could have effectively driven a witness off the stand? I mean, that's the language that we've used.
That is the language that was used. The state would argue here, as a point of fact, nothing deterred her from testifying. She did, in fact, testify.
Well, and Strout, there may be a distinction between Simmons and Strout for that reason, because Strout did, in fact, testify, right?
Correct.
Okay. And so in order to find a violation, is it your position that somehow with Simmons it would have to be proven that it was, first of all, remarks of either the state or the judge, for that matter, that kept Simmons indeed off the stand?
Improper remarks from one or the other, because again, based on Fagone, that witness, Mr. Simmons.
And the first step, I guess I'm thinking of it as sort of two steps. That it
Okay.
has to be remarks from either the prosecutor or the judge, as opposed to his own attorney. And that second of all, they had to be improper remarks.
I would agree with that, Your Honor.
Okay.
And by improper, do you mean threatening or intimidating?
I think so, Your Honor.
Or is it beyond that?
At least unduly threatening and intimidating, which has been explored by these various other cases. And again, we don't even meet the first step of Madam Chief Justice's test, because there were no statements or remarks made by the court or the prosecutor to Mr. Simmons.
Or by government agents of the prosecutor?
Or by agents of the prosecutor. There is nothing in the record to suggest that at all.
And that goes back to what I said at the beginning, that we don't know exactly what was said to Mr. Simmons.
We have what is in the record, Your Honor, and I don't want to argue outside the record. And likewise, I do not think it's proper for appellant to invite the court to take on a fact-finding role and attempt to generate some sort of inference from what's in the record. It just amounts to arguing outside the record.
There don't appear to be additional questions.
Thank you, Your Honor.
Thank you. I'd like to switch back to the first assignment of error.
But I'd like to keep going on that one for a moment.
Great, thank you. What's your question?
Well, it was the question I actually was going to ask. So with regard to Ms. Strout, who did indeed testify, I mean, there is nothing on the record to suggest that she was effectively driven off the stand, or indeed that her testimony was changed as a result of any comments made, never mind whether those comments were improper.
I'll concede that. I'll concede that. And I think also the only possible response to that is that defense counsel was talking up her testimony before that, and it didn't seem to live up to the expectations that I was expecting as the reader of that. But other than that, I concede that point.
Okay, thank you.
So where in the record is the threatening and the intimidation of Simmons?
To Simmons, I have the notes here. To Simmons, so there's...
That were actually communicated to him as reflected in the record.
one in the hallway. There's two officers, at least two officers, and the prosecutor. This is at page A61, so 61 of the appendix, going out there and saying, we have listened to your phone calls and we're not calling you as a witness anymore. I think there's
And
only...
is that incorrect?
Is that incorrect? That's
Or
the
improper?
representation of the prosecutor.
Is that improper if that's what was said?
I do think that there's a potential for that to be improper. I think telling you we're not calling you because we think you're going to lie is probably going to shade somebody's testimony. If you want to conform and not be prosecuted for perjury, you're going to, certainly any reasonable person is going to back away from
But what
how
you
they're
started
going
off
to
by saying
testify.
is not, that's not what it was. It was, if we've listened to your phone calls, giving the preference
Right.
of that.
And I think from defense standpoint, that it's certainly possible that the proffer that the state received was the incorrect version, and that whatever they heard via the phone calls was going to be the correct version. And in fact, that's what should have been left for the jurors to decide, but he wasn't called at all.
Counsel, can I ask you, do you, there was a representation that that the record does not establish that Jalbert claimed ownership of the Walmart bag. Do you agree with that?
That Jalbert himself did not say, I own that Walmart bag. Correct. That came from the defendant, that statement, that so-called hearsay statement that was admitted in evidence. That's at page 215 and 172/173. There's another, it's touched on as well. But I think that goes to my point. I do agree that there's a gulf in readings of the facts between the two briefs. And I think the state simply misheard the argument that defense counsel was actually making and objected to something that he thought he was hearing. If I, Your Honor, may finish this thought briefly, I'd appreciate it.
Go ahead.
All right, thank you. And that changed the effect. And we see that now in the briefs, where there seems to be this reading by the state that no, defense counsel was actually saying that Jalbert had made those statements. But that is not clearly from the transcript what is being said. What's being said is there were statements in evidence that Jalbert owned those drugs. And if there was any question about that, that's exactly why such objection should be handled at sidebar and not ruled on by a judge who lacks independent memory, as he later said, in a conclusive and binding way in front of the jury. Thank you.
Thank you, counsel. As is our usual practice, we will, of course, take the matter under advisement and issue a written decision in due course. And with that, I believe we are done for the day.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court, may hence depart and give their attendance here at 9:50 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.